for the property located at 2123 11th Avenue North. Do we have anybody here? Are you in opposition? I'm sorry? You're opposed to it? Okay. Doug's here. Okay, good afternoon, everybody. This is the Metropolitan Board of Zoning Appeals, which is now in session for its regularly scheduled meeting of April the 2nd. I'm Bill Herbert, and I will be presenting the cases to the board for review in today's public hearing. At this time, I would ask that everyone either turn off their cell phones or put them on silence so as not to disrupt today's meeting. The procedure will be to introduce the case record. We will present site plans, photographs, and maps of the properties involved in today's cases. We will also present any letters we have in support or opposition to a particular case, as well as any correspondence we have received from other governmental agencies. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there's opposition to a case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for a time of rebuttal. The board, in their rules, provides the appellant in cases without opposition 10 minutes for the applicant to present their case. In a contested case, the board provides 15 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some additional time from their allotted 15 minutes. All sections, numbers that we refer to today come directly from the Metropolitan Zoning Code, which was adopted by the Metropolitan Council and became effective January 1, 1998, and applies to the entire jurisdiction of the metropolitan government. I'll introduce and make a part of the record the entire zoning code, and we will dispense with the reading of individual sections unless the appellant or opposition requests their reading. The zoning code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through all of these cases set for public hearing today. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the following provisions as outlined in the Metropolitan Zoning Code, Section 1740-180. The code requires 4 members of the 7-member board to be present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. In the event there are only 4 members present and there are not 4 affirmative votes, the application will be re-advertised for the next available public hearing cycle. In the event there are 5 or more members present and there are not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, the appellant or any aggrieved property owner may also appeal this board's decision to Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that a permit must be obtained within 2 years for the board's approval to remain valid. I submit that all cases have been filed in the proper order. All appellants have been notified by certified mail as required by the code. All affected property owners have been notified and the legal ad has been published in the Tennessean as required by the code. Are there any elected officials here today who would like to speak? Board seeing none. Preliminary announcements. I don't think that we have a consent agenda today. However, for the property for the case that is 2015-034, the one that I just called out, Sylvia McCarthy, for the property located at 2123 11th Avenue North. If the parties would like to get together and discuss that case while we're hearing other cases to see if there's a possibility of a resolution, we'd encourage you to do so. With that being said, this board does not have a consent agenda for today. The cases will be heard in the order that they've been handed to us. And do we have anything further, Mr. Chairman?
That will be referred for.
Thank you. Yes, case number 2015-033, which is Bethel World Outreach Church, located at 5652 Granny White Pike, has been deferred to the May 7th meeting. So anybody here that's on that, it will be heard on May the 7th. Mr. Chairman, anything else?
Is now the time to go through the fact that only certain of us can hear the first case?
Yes, we'll do that. And I've been remiss in not introducing our brand new board member. We have Ms. Christina Karpenick, who is joining us to the Board of Zoning Appeals for the very first time. This is her first meeting, and welcome. Glad to have you. Mr. Chairman, what was the
first case? I think only certain of us can hear it because it's been.
Right. This will be the very first case. This will be the third hearing of this first case. It has been deferred a number of times. It was actually deferred more times than that due to weather. But each time the board has granted the applicant's request to defer in order to gain additional information. So with that case, Ms. Karpenick, you were not involved in the prior decisions or the hearings of this case. So for this case, you reluctantly cannot participate. So I hate to do it to you for your very first case on your very first meeting, but we'll have to ask you to please step up, and you can step out in the back. There's a conference room in the back. Just relax, enjoy yourself while the remainder of the board hears this case. Mr. Chairman? Okay, I guess we'll go ahead and call the very first case. The first case to be heard today is case number 2015-009. It's Mr. Dwayne Cuthbertson, appellant, and Shelby Street Partners, GP, owner of the property located at 1002 Lawrence Avenue, requesting variances in the side street, 10th Avenue South setback, and the garage door facing the side of the street in the R8/UZO district. And they are asking to construct a second new single-family 2,467 square foot residence. This is referred to the board under section 1712.030C2 and 1720.060D. The appellant has alleged that the board would have jurisdiction under 1740.180B. Mr. Cuthbertson, if you'd like to come forward. Do we have any opposition here today for this case? Seeing no opposition, Mr. Cuthbertson, you have 15 minutes.
Well, Mr. Chairman, before I begin, I've received communication from the Neighborhood Association president that she is going to attempt to make this meeting. She's made 2 previous meetings, and I'd like to request if we can move this item down the agenda just to give her a little more time to just show up, if that's something this board would entertain.
That's fine.
I'll move, we'll hear it next.
Yeah.
Let's hear it. Yeah, put it on the heel if we could.
Okay, Mr. Cuthbertson, I said that you had 15 minutes, you actually would have 10. Okay, so we'll move to the next case on the agenda.
And I'm sorry, I'm going to need to recuse myself from this case because my law firm does work for the applicant.
Will you go get it?
And I'll go get Christina because I'm headed that way.
While we're retrieving Ms. Karpenick.
Bill, I'm also recusing myself from this particular case. I've been doing some historical consulting for this matter.
Okay.
Our new board member out. Chris and I will be in the cone of silence.
I'm still here, but I want to do a disclosure. I want to disclose that I know one of the appellant, Mr. Barkley, and I worked on a project together years and years ago. We've not worked since, but I just wanted to disclose that. I have no interest in this case other than I did work with one of the developers.
Okay.
So if anybody opposes, I'll be glad to step aside.
Does anybody have any objection to Mr. King remaining on this case? Okay.
Sir, we're here for the opposition, and my client objects to participation.
Okay. Mr. King, we have an objection from the opposition in this case. This is going to be your decision as to whether or not you feel like you can, without bias, objectively hear this case and render a fair decision.
I can render a fair decision. I just wanted to point out that I have not seen nor had any dealings at all with that person. I just wanted to bring that to the forefront. Thank you.
Okay. We've got 5 board members, and it takes 4 affirmative votes to grant the application. And so we can go ahead and proceed. We'll go ahead and call case 2015-022. This is 4Pant LLC appellant and 4Pant LLC owner of the property located at 210 4th Avenue North, requesting a special exception in the height restrictions to the downtown code in the DTC/MDHA-CM district, to renovate existing building and to construct additions across 4 buildings and cover all to a 10-floor hotel development, and convert all to a 10-floor hotel development. It's referred to the board under Section 1716-140, Section 1716-150, Section 1737-110. The appellant has alleged that the board had jurisdiction under 1740-180C. We have let the record reflect that we have Ms. Carpenter back for this. This is the first time this case has been heard, and I'll hand the presentation over to, well, first of all, where's Mr. Harrison? Okay. We'll have Mr. Harrison go through the PowerPoint that the office has put together, and then we'll hand the case over to the applicants.
This is a map of the area. This is Church Street, 4th Avenue, Bankers Alley here. This is a site, these 4 parcels there. Here's an aerial view of it. Come on. This is where the height variance would be in, showing where the yellow highlighted part is the part that's in the, would need the variance. Or excuse me, the brown part. That's the existing building on the other side, and they're trying, the yellow part is theirs. This is another view of the building from the street, looking at it. This is the existing building here on the right-hand side, and the new building to the left. Another view. This would be, looks like, from the rear. This view here, this is showing again the maximum height. 6 stories, proposing 10. Another view of the new building there. That's off the other side of the building. And here's some photographs from the street. That's from 4th Avenue looking into it. That's looking down the street from it. That's across the street, the old Third National across the street. And that's what we have as far as the pictures and the presentation.
Before we get started with this, I would like to let the board know that there is a letter that has been added to your packet that I laid in front of you from the Historic Commission. So I'd like to draw your attention to that letter in support of the project. Also, the Planning Department has written their recommendation as required whenever we have a special exception come in front of you. And I have here today Mr. Doug Sloan, who is the Assistant Director of the Planning Department. And Doug, because you're with the government, I'd like for you to step forward and state their position. Then I'll hand the case over to the applicant, and then the opposition will be allowed to come from in the normal order.
Hello again. For many of you, it's been a while since I've been in front of this board. The first thing that I would like to address, obviously you have our recommendation in front of you, but the first thing is really that the height modification. In the DTC, it specifically states that any kind of height variance or special exceptions to come before the BZA, and that's how you would get a height modification that would occur other than bonus height that you can also get. There's an also section in the DTC that allows for bonus height. And so we met with the development group several times as they went through the different iterations of the development, and I'm very pleased to say that a lot of the modifications that they've made to their development have been to increase or I should say improve the pedestrian environment along this project, which is one of the specific things that must be done for a special exception for height modification in the downtown code. The modifications, or I should say the changes to their design plans that I've taken note of in particular are the fact that they have created a plaza area, an atrium really area in the middle of their project that opens up to the sidewalk. Additionally, the new development is set back behind where the historic structures are at the curb, which and I'm not sure, there's no one here from Historic, but that highlights those facades of the two historic structures, but also, quite frankly, widens the sidewalk at those locations. The openness between those two buildings also, again, I think really enhances the pedestrian environment there. Along the Printer's Alley in the back, we also had lengthy discussions about how there would be activity there at the street. And the same thing goes for 4th Avenue. We had lengthy discussions about what would the first floor of these units look like, or the first floor of the hotel look like. And would there be activity? Would there be the lobby, restaurants, and that type of activity? And they have designed it in a way where there is activity for the full length of the development. The same concern was taken from my office to them, and they, I think, gave the same attention to it along Printer's Alley, in that we wanted to make sure that Printer's Alley, one of the great things about it is that there is activity throughout that stretch of the alley, and they have done the same thing. We were concerned that they might try to just make it as a garage, but that's not at all what's happened. They've really opened it up quite a bit, but kept an active street front all along Printer's Alley as well. One of the things that I will, since Tim's not here, one of the things that I will talk about, because our departments met with this development group together, and one of the things that we were very excited about is the opportunity to save historic structures in downtown Nashville. That's something that comes at a great cost, and we realize that, but in this development in particular, I certainly will let the development team speak to this more, but they went through extraordinary measures with us to try and preserve as much of the structure as possible. In the Climax Saloon, I'm not sure there was another name. I'm sorry? Utopia Hotel, that early on, they had a design that just showed a facade there at the front. And after touring the buildings with them and talking with them, we expressed our desires to see more of the hotel stay. There are front rooms on the first 3 floors that go back about 20 feet. And they were very receptive to that and went back and redesigned the entire hotel to make that possible. I point all that out because a lot of the modifications, so the height that I believe that they're asking for is in direct response to floor area that we would ask them to essentially remove. They had floor area and we were asking them, can you save more of the historic structures? And we were willing to support the additional floor area being taller in this area if they were able to save more of the structures. And they went through the effort and I think did a spectacular job in doing just that. So I would point out that I really believe that the modifications that they're asking for, the additional height that they're asking for, is directly related to the request the city has made of them to preserve the historic structure. And I don't know if the board
I
has any
think as you
questions.
were talking, I was looking at the planning recommended approval with 5 conditions, and as you were talking, I think you hit all the 5 conditions and they seem to be met, but I just wanted to get your say on whether or not you felt like that the proposal as we see it now meets the planning department's recommendations.
We do. We believe that they literally have been responsive to every request we've made. And so I believe that this design, the last iteration that they showed us, touches on all of those requests.
Great.
Thank you.
Thank you, Mr. Sloan. We ready to open for the presentation, or we have more to add?
No, I think we're ready to go forward with the presentation, and we'll turn it over. Each side has 15 minutes, and if the applicant would like to reserve any time on the back side as rebuttal, please let us know and reserve it now.
Great, thank you. Mr. Chairman, members of the BZA, my name is James Weaver. I'm with Waller Lanston. Whoa, they got loud all of a sudden. And I'm here today as counsel for the applicant, Forplant LLC. Today's a celebration. This has been a long process, working hand in hand in concert with not only codes, who's been the staff has been absolutely magnificent during this long design process, but also with the planning department, historic, and MDHA, the mayor's office. The entire city government has been involved in the efforts to save these 2 wonderful old buildings, and we're very pleased to be here today with a design and with a program and with a project that preserves 2 of the most important buildings in downtown Nashville. I have with me today Alex Marks and Bill Barkley, who are the developers of this project, the owners of this particular project are Nashvillians also. This is very much a Nashville-centric project. The purpose of this special exception that we're requesting today is relatively simple. When we started this process, as has been set out by Director Sloan, we came in with a design that fit the downtown code and didn't require us to be in front of you today, but it really didn't at the end of the day save the buildings. It preserved the facades, but it didn't preserve what's important, unique, and special about these buildings, but it fit the code. And it's interesting that Director Sloan, his description of those meetings, it didn't feel so much like a request if you were in those meetings. It felt a little bit more like go home and do your homework and come back and save these buildings. And so that's what we did. And we worked with wonderful architects at ESA. We brought in some historic preservation architects from Texas, and we came back with a design that meets our financial objectives and the financial necessities of doing a project this expensive and this elaborate in terms of key count. This is a hotel, while preserving to an enormous extent these really important structures. in talking to codes and staff and talking to the planning department, it was determined, and in looking at the downtown code, it was determined that a special exception was the way to go forward, and that's why we're here today. And I'll touch on a little bit on that a little later on in my presentation, but I'm now going to turn it over to the real heroes of this particular process, which are the guys who have designed this, and let them walk you through a little bit of what we're proposing and what this is going to be when we're done, if we're lucky enough to get your approval.
Thank you. We're going to do just a very quick presentation to get some of the highlights of where we're at.
Would you turn on your microphone there, please? Thank you.
I believe it's on.
It's on.
So we're going to do a quick presentation of where we're at today. This is an existing photograph showing the existing Utopia building, which we're going to save and keep it in its entirety. The side of this building we're trying to keep as a public, as a courtyard, and that courtyard then will emphasize the fact of that existing building. And then the existing Embers building, we're saving this facade and as well as the courtyard facade and stepping back a new building on 4th Avenue to represent the facade of that as well. So it will be representative, and you can see the historic nature of those two buildings. Why we're here today is to talk about the special exception. The existing Utopia is about 90 feet tall, give or take, and we're needing to go about 135 feet above the Utopia, so it will be a 10-story building instead of 6. And also the Knoll building is next door, adjacent property, and that is still below our property. So that just a point of reference of another surrounding building right next to us. The other thing we wanted to do is emphasize this building. So what we're doing is stepping back this portion of the building approximately 20 feet to, again, further emphasize that existing building. This facade steps back about 2 feet. And in the backyard is that open courtyard. This is in the foreground, which is stepped back 25 feet. So that will get that interplay of the sidewalk community also into our project and further on into the courtyard. This is a view of Printer's Alley. This is the Utopia building, which we're saving. The rest of Printer's Alley in this darker color is what's there currently, and we want to save that. We want the flavor of Printer's Alley to remain. That's important to us as being Nashvillians. And then this is the new building, and this area here, the code talks about stepping it back at the 4th story level. We're going to step it back at the 2nd level, again, to emphasize this is the more historic and what has been there and preserve that character. And then lastly, this is a site plan also talking about that setback along Printers, which is about 5 to 6 feet, and then our step backs at the entranceway and so forth. So that is a quick presentation, but I think you might be familiar enough.
And the other piece is in the code, downtown code, it talks about a 90 by 90 building mid-block, and our building is not 90 by 90, it's 162 by, roughly it's 200 square feet over the 90 by 90 rule. So that is one of the fourth point. And the fourth point.
And the fourth point also on 4th Avenue, they have a restriction of the storefront along 4th that it needs to be 18 to 24 inches high, and we are proposing that would be about 36 inches high, so slightly higher.
Only in 2 spots, it varies, but that was the other fourth point.
Mr. Chairman, again, the design process that we've been through has been a collaborative process, working closely hand in hand with historic, with planning, with MDHA, with the Downtown Code Design Review Committee. However, in order to go forward with this design and this project, we need your support. The Downtown Code Design Review Committee has approved this design and recommends it to this board for approval. The planning staff, as you've already heard, supports this design and worked with us hand in hand as we came up with the same. Historic you have a letter in front of you from the Historic Commission. They worked with us hand in hand every day on this design, and they support this design. Council Lady Gilmore, this is in her district. She supports this design and asked this board to approve this application. We had a community meeting. with our neighbors. There is some residential in this general part of the city, particularly on the Printers Alley side. We've worked hand in hand with our neighbors, and you have letters in the file from our neighbors, and our neighbors support this design. The mayor's office, the Convention and Visitors Bureau. This is going to be a cool, hip, I'm not at liberty to say which New York chain hotel this is, but this is going to be a very, very important addition to the hotel mix in the downtown Nashville. So everyone that has worked on this project, everyone that we've involved with Metro has worked with us and is supportive of the application before you today. However, there is opposition to this application. It's from a competitor. The Indigo Hotel, which is down the street and around the corner, will come here in a few minutes after I speak and oppose this application on a technical ground, and I'll touch on that in a minute. But let's make sure we understand what's really going on here today, and that's competition. And I don't like competition either. I wish every morning that Mr. Whitson would retire from the legal biz so that I didn't have to compete with him every day, but that's probably not going to happen. But that's all this opposition is. This is not about height. This is not about view shed. This is not about historic preservation. This is about competition, pure and simple. I want to be very, very clear. It is Walter Lanston's opinion. It is the Planning Department's opinion. It is the Code Department's opinion that a special exception is the appropriate mechanism to approve this height. Period. Hard stop. The special exception is set out in the downtown code as one way to approve this particular type of deviation from the code. The reason for that is simple. The downtown code clearly indicates that height can be approved in the downtown code via a special exception or a variance. The downtown code says nothing that makes a variance mandatory. We've got enormous amount of documentation in front of you. You've got a brief in the record from my partner Erica Garrison, who's so much more attuned to this stuff than I am, and I apologize. She's in Florida, and she's probably watching this on the internet right now, and you're having to listen to me here today. But a special exception is a perfectly valid legal way to do this. And in working with codes and working with the planning department, that's the mechanism that they suggested that they would ask us to use in order to put this in front of you, and that's why we're here today. Pursuant to the special exception standard in the code, 1716-150, our request meets the minimum requirements for a special exception. The additional 4 stories maintains the integrity of the adjacent areas. It maintains the design and architectural compatibility of the surrounding property. It promotes historic preservation. It promotes safety and, quite frankly, solves a fire hazard associated with these abandoned historic structures. It has no negative vehicular impacts and has an enormous positive pedestrian impact on this part of 4th Avenue. Our request improves the pedestrian feel of 4th Avenue and does nothing to negatively impair the light or the view sheds of the surrounding properties. For that reason, we ask that the Board of Zoning Appeals approve our application. And Mr. Chairman, with your permission, I'd like to preserve my 4.5 minutes for rebuttal if necessary.
Okay, thank you for the presentation. We'll have 4 minutes and 21 seconds.
Mr. Weaver, do you want to make your exhibits part of the record for today?
I do, yes, thank you.
Okay, thank you. Mr. Denton?
I'll take the podium if that's okay with y'all. Do you prefer? Whatever you
I think it's up to the board.
Whatever the board prefers, Mr. Chairman.
I don't care. What do you prefer?
Okay. Good afternoon, members of the board. Good afternoon, members of the board. My name is Joshua Denton. I'm an attorney down the street at Gullett, Sanford, Robinson, and Martin. And I'm here representing Tennessee Union Owner LLC, which owns the building at 301 Union Street, which abuts or adjoins Printers Alley, borders Printers Alley. I've got with me Mr. Bill Basilieri, who's the general manager of both the building and the Hotel Indigo. And they are correct, the Hotel Indigo is housed in that building along with law firms and other folks here in Nashville. I really appreciate the collaboration that the applicant went through with the city and with all involved. But with all due respect, the proper vehicle for this to be approved is a variance and not a special exception. And so that's what we're here on today, is that fundamental legal issue as to the basis for the request. And so we oppose the special exception application filed by Forpant for that reason. As the board knows, this property is located in the core historic subdistrict under the downtown code. The adoption of the downtown code is memorialized in the zoning code itself at section 173710. And my understanding is that this is the first time that an application for an alteration of the height standard under the downtown code has reached the board. That's my understanding from the staff. I know one was filed previously as a variance and a special exception request and was withdrawn. And I believe they did that appropriately. But to highlight, the downtown code is a regulating document. It's part of the code, and it was designed and drafted and approved to provide a common vision for the future of downtown Nashville. It envisions these multiple distinct neighborhoods for downtown, each with their own specific character and scale. And it provides a clear direction on the maximum development allowed in each of these subdistricts. And the reason is to preserve that character and scale of those subdistricts. The property.
Excuse me, sir.
Yes, sir.
One moment. I want to stop and ask our attorney a question about this. If his opposition, as it appears to be, is to the fact that they're applying for special exception, then isn't that that's not? It seems like it's more like an item A issue, and it seems to me that this opposition could be raised only after if we approve this. If we didn't approve it, it would be moot. I don't know if I'm making myself clear or not, but it seems to me. I
think I understand what you're saying. I hadn't thought about that before, whether or not the decision to utilize the special exception as a tool by which to address the height request here should be properly brought as an item A appeal to the zoning administrator's decision to bring it to this board that way. I don't know that it couldn't be done that way, but I don't know that there's anything wrong with the opponent addressing it in this form without bringing an item A. I don't think the code requires that. Let me say it that way. I don't think the code requires that he bring that solely as an item A. I think he can also raise his objection in this form, since in fact it was actually brought and the application is actually pending before the board.
And the item A appeal would still be an option if we did approve to the
No,
opposition.
I don't think it would still be an option at that point. At that point, his option would be to appeal to Chancery Court, the basis of the decision before the board. I mean, it would just be a regular appeal to Chancery Court of the board's decision at that point. I don't think at that point, since the board has already ruled on it, that would be the vehicle that he would take if he disagreed.
Okay,
because at that point, it's no longer just a decision of the zoning administrator.
Right. Well, and I guess my question. I guess my question is twofold. I mean, obviously, it makes perfect sense to have opposition at this stage, but I'm trying to figure out if and I don't want to make the argument for him, but it does seem so far that the argument is that this is not the proper course for this to move.
That appears to be one of the arguments. I have read his brief, and that's not the only argument that I think he's going to bring before this board.
Which I'm curious to know that if it is approved and that item A is then closed for him, then he, in a sense, never gets to make the item A argument on its own.
He's making it now.
Yeah, in fairness to the appellant, let's let him finish his presentation.
But I think this has to be cleared up, because he's not making an item A appeal, and by making this argument, he will not, depending on how we vote, he may not, well, actually, by arguing now, he will never get to make an item A appeal, if I'm understanding what you're saying.
Mr. Chair? From my perspective, what Mr. Denton is doing is presenting a defense to the application, and his defense can be based in law or in fact. And this defense is based in law. And I've practiced for years in front of boards of zoning appeals, and so in my opinion, his defense is appropriate to be heard by this board, because the applicant has made an application and a request, and Mr. Denton has a defense to that, and his defense may be partially in law or in fact, or both. He's presenting a legal defense at this point. He may have a factual defense that he wants to present as well, but I think that's his prerogative to do so at this point. And whichever way the board votes, either party may appeal by common law writ within 60 days to the Chancery Court, and then the Chancery Court will hear it to determine whether or not the legal defense that was presented was that the board voted legally or not. Does that help?
It helps me, and that was my point. I think we owe it to the appellant to let them finish their presentation, and then what you're saying, I think, can come into our discussion.
And that's, and I'm not, and I'm sorry to interrupt, I just wanted to get this clear. I just wanted to make sure that we weren't putting any carts before any horses or anything like that. And if everyone is happy with that course, and I'm certainly happy with it. Thank you, sir.
Thank you, Mr. Harper. Thank you, Mr. Chairman. And I'm more than happy to take questions as you all have them if they pop up. Glad to do that. So this particular property is in the core historic subdistrict as defined by the downtown code. The height maximums in the core historic subdistrict were designed to reflect historic urban design features and specifically providing for lower buildings mid-block with taller buildings bookending the street. So you got taller buildings at the corners and lower mid-block. The downtown code specifically provides that any new construction is required to be of appropriate scale and detailing. Again, with the downtown code focusing on the maximums and keeping that character and scale of the particular subdistrict neighborhoods. And in this subdistrict, the maximum height for a corner building is 10 stories, and the maximum height for a mid-block building is 6 stories. And that's what all the input, all the drafting, all of the extensive time and effort to get the downtown code put together and actually approved by the city of Nashville, that's what was found. 6-story mid-block buildings, 10-story bookends. And we know here, and Counsel for Forpan has acknowledged this, and his partners acknowledged it on the phone to me, that they have the ability to do this development meeting the criteria of the downtown code with those 6-story buildings in the mid-block, and will have the same number of keys to do what they need to do. So with all due respect, this is not competition in that sense. I mean, we know they have been very clear they're coming, and they're coming with the same number of keys. We have a hotel that's right on the corner of Union and Printers Alley, and our whole, if you've been to the lobby, you know it's all about Printers Alley. I had lunch there today. It's designed all around that. They've put an enormous amount of money in that. And that's similar to the folks who drafted the downtown code. We want to preserve that character and scale of this particular subdistrict neighborhood, and the code's already provided for that. So the application seeks to interrupt the design features that the drafters of the downtown code have put in place. They're inserting a 10-story building mid-block. And so in that case, we believe, and we put forward in our brief, that the downtown code expressly requires a variance. I heard Counsel for Forpan earlier say that a special exception is one way to deviate from the height restriction, and that you can go with a special exception or a variance. With all due respect, the downtown code doesn't say that. Their own response brief doesn't say that. What the downtown code says is, on page 14, variances and special exceptions to the downtown code standards on height at the street and overall height shall, not may, shall follow the procedures set forth in Chapter 17.40, Articles 7 and 8. Article 7 is special exception, Article 8 is variance. So variances and special exceptions to the downtown code standards on height at the street and overall height shall follow the procedures set forth in 1740, Articles 7 and 8. And with all due respect to the city and all the work that's been done on this, and I do appreciate it, the bottom line is it's this board, and I'll go through some more here about why I believe it's a variance, but it's this board's job to make the determination as to what procedure to follow. And yes, sir.
I've got a question, because you just had said that you just had quoted variance and special exceptions that are not specifically for standards of the downtown code. Shall follow the procedures of chapter 17.4, 7 and 8. But the appellant also quotes that as evidence that they're right. So, I appreciate you saying this is why I'm right, but it doesn't tell me as a non-lawyer really why you're right,
Sure.
Because they're going to come back and say, no, that this gives us permission. So if you could be a little bit more specific. And then also you talked about how important it was for the historical core to be maintained in terms of the rules and regulations, but at the same time, it sounds like that your preference is to tear down the two buildings and keep the facade. And it just seems like that there's a part of what you're saying that misses the efforts of the two organizations in town that I think are probably best equipped to keep that historical aspect going, and that's the Historical Commission and the Planning Commission. And so if you could help me understand the conflict I'm understanding there, and then specifically why that code applies to what you're saying, I would appreciate it.
Certainly, I'll be happy to address both those points. We are quoting the same language. The language says variances and special exceptions to the downtown code standards on height at the street and overall height shall follow the procedures set forth in those articles. The difference is and or, okay? What Counsel for Forpant said was that you could do a variance or a special exception, basically at the applicant's election, either one. The code does not say that. The code says special exception and variance. The standards under those shall be followed. Those procedures shall be followed. What they want you to do is read this and say, it's either one and it's at my election. So, today I want to file it as a special exception because that's a lower, easier standard to pass, and I don't want to file it as a variance. I don't know anybody who'd ever file a variance request.
The other question I have is if you had said that I think originally they might have requested a variance and a special exception. Let's say they applied for a variance with the exact same plan that they have now. How would that impact the plan that we presented? Why does that matter?
There's a different standard for approving a variance. This board has a different standard for approving a variance versus a special exception. A variance, it needs to be is a proper to be approved, and we can pull the code out and read it verbatim. But if there's some topography, shallowness, narrowness of the lot that requires that, whereas the standard for a special exception is much lower.
Yeah, I understand that. I just wanted to hear it from you. That the project wouldn't be the same. So I understand that.
Yeah. And so, you had another question. You had the question about the language, and then the historic nature, I guess, is the other issue.
Yeah, they had said, they could have done it without coming to us, but we would have lost two historic buildings and not achieved the goals that the Metro Historic Commission and the Metro Planning Commission specifically have for downtown, which, I think fed into those standards that you're talking about. So I guess why would you prefer that over what we have now? Well, the downtown code speaks to the character and scale of the neighborhood, not particular buildings, really. And so that's what the downtown code is going to. And, the city has not chosen to put these particular buildings in a historic overlay. I hope they're saved. I very much hope that. But the issue here today is whether the downtown code allows for them to get this height variance or based on a variance or a special exception. So.
Earlier on, you were talking about the number of keys for the hotel. Were you saying that they could do the same number without the variance, or did you speak to that? I remember you said.
That's what I was told by their lawyer.
Okay.
When I filed our opposition, I was called and told that they were coming regardless of whether it was approved, and they could do the same number of keys, the same number of rooms.
So, just to simplify for me for a second, you are opposed to the additional height, or you are, or opposed to the process by which they're seeking relief?
We're opposed to the additional height, and we don't think they've gone the proper avenue to seek to make that request. And if they did come forward under what we believe to be the proper vehicle, what the code says is the proper vehicle, the variance, we would be opposing that they were meeting those requirements.
And your opposition to the height is that it does not follow the core requirements of the 10-story bookends and the 6-story mid-block.
All of those things that there was so much input from the city of Nashville on in drafting and preparing and adopting this downtown code, the reasons that they decided they thought that was important, it's the same for us. So.
I just got one more question on, and I wasn't an English major, so I'm going to harp on this and or just for a second. But it doesn't seem to make much sense to me, as I see it, in your argument that the and would exclude, would require them to have a variance, because if variance is more restrictive, as you said, why would you ever have a special exception? It just seems because of the nature of those two rules that you would have one that it does, you say variances and special exceptions that are not specifically for standards. You can say, hamburgers and hot dogs. I mean, that to me, as I read it, it's, if you have a variance, if you have a special exception, these other rules apply. So I guess I just don't get that point. I think it's pretty critical to what you're doing, and so that's why I want to give you a chance to answer it, but I don't get it.
I so appreciate it, and I'm glad, like I said earlier, glad to take questions. Typically, a special exception is going to use, okay? So you may have a property that's zoned A1 agricultural, and you can put a professional medical office building there in that zone, but not automatically. You have to go and get a special exception for that use. So that is the typical vehicle for a special exception. Variance is usually something like height, setback, those types of things. So a typical example of a variance would be where you have a parcel of property and there are setbacks, and it says, okay, you can only build in the middle here. You got to be set back on 20 feet on all sides. And there's a creek running through your property. Okay, and so you can't build right in the middle. So then you go to the board and you say, I've got a hardship. I can't make use of my property without getting a variance from the setback. And so that's how that typically is, and the special exception typically is for use. Although to their point, in Metro's code, they do account for height special exceptions, and they talk about that in their brief. And they say in the urban overlay, let me just make sure I get it right, the urban zoning overlay, it does provide for a special exception for height. And they said in their response brief that they filed Monday, we've talked, and because it's harder to get a variance in downtown, which to your point, then the government has adopted a code provision that says you can get a special exception on height in the urban overlay area. The problem is there's another section in the code that says the urban zoning overlay does not apply to the downtown code. The downtown code is specifically excluded from the urban zoning overlay. So if this were just in the urban zoning overlay and it wasn't part of the downtown code, they could come and get a special exception for height. But going back to the downtown code itself, it's very specific about those height levels. And there was a mention earlier about the bonus height program and being able to get bonus height. If you do a LEED certified building or you do a parking garage, something that you do that helps the community, we're going to give you an extra story or two. And there's this chart set out in the bonus height program that's in the downtown code, and it says how many extra stories you get for doing something extra. And in this sub-district, you get none. You can do everything on that list. The drafters of the downtown code said, we're not going to give you any bonus height. It's just like 2nd and Broadway, the Central River District. There's no bonus height for those special areas, and this is one of them. So it goes against that they should be able to file and willy-nilly get a special exception. It's a higher standard, and the code says so in black and white. And so that takes you to the downtown code says variance and special exception procedures shall be followed when you're trying to get around the height standards in the downtown code. And they give you those two articles, Article 7, Article 8. Article 7 is the special exception. That's there. There's nothing in the special exception for Article 8 that speaks to a height variance. They do speak to height variances in the urban zoning overlay. They do speak to it there, but they specifically carve out any properties in the downtown code. They just carve them out. It's not included. They're excluded. And then you go to Article 8, which is variance. And Article 8 is very important. Article 8 says that this board shall not have the authority to grant any variances as to the downtown code. Says it right there, except in a footnote. It's a footnote, and that's fine. Except that they may grant variances as to the height at the street and overall height level with a recommendation from the Planning Commission, not the Planning Commission Department or the Planning Commission staff, with a recommendation from the Planning Commission. And so it says right there, board, if you are going to grant a variance, you can't grant one under the downtown code unless you do it as to height, and then you've still got to follow all the requirements for a height variance, for a variance, that topography, all those narrowness, shallowness, all that. So it says it right there as plain as can be. When you take the downtown code referring you to Articles 7 and 8, you go to Article 8, it tells you what to do. It says you may grant one for these heights to vary from the height standards with a recommendation from the Planning Commission, and then you still have to meet the requirements. So the language in the code is not permissive, it's mandatory. The Planning Commission's made no recommendation. Let's see. We've talked about the fact, the applicant's points about a variance for height being too stringent a standard in downtown, and that the code does address that for the urban zoning overlay, but that section 1736-440 says provisions of the urban zoning overlay district shall apply to all properties located within a mapped area indicated on the zoning overlay map, excluding property zoned downtown code district. And this property is zoned that. So in short, the applicant's reading of the downtown code and the zoning code itself would necessarily render provisions in the code meaningless. And it's just a very established principle that when you're reading statutes, ordinances, codes, you are to read them to give effect to the words, not to render them as having no meaning. And that is essentially what they would have this board do. They would have the board read out the requirement to get a variance. They'd have the board read out the provision that says that the urban zoning overlay doesn't apply to the downtown code, because they want to rely on that and say, well, this is why we get to do a special exception instead of a variance in the urban zoning overlay. And that's right, but it doesn't apply to the downtown code, and the city is who made that rule. There's no question a variance hasn't been sought. We know that they can develop the project within the downtown code standards and have the same number of rooms. That's not really relevant, but it is I think, an important point. This board is only permitted to grant a special exception where the zoning ordinance provides it may do so. That's set forth in the Tennessee Code at 13.7206, so the authority is limited. And the downtown code and the zoning code expressly provide that a variance is required to alter the height standards set forth in the downtown code. That just is what it is. That's how it's written. And that's what we submit should be applied. And as I mentioned, the only other application I'm aware of where somebody sought to alter the height standards under the downtown code did so by way of a variance and a special exception request. I understand that was withdrawn and never reached this board, but that's how they applied. So I know there was a great deal of thought and input and work by the city and by the applicant, and I do appreciate that. But there was a great deal of thought and input and work done by the drafters of the downtown code and by this city government in adopting the downtown code. And so the board is required, we submit, to follow and enforce the code's express terms. And for all those reasons, we ask that the application be denied.
Any further questions? Let me get one thing clear.
Yes, sir.
You're saying that the recommendation on the sheet that we got here from the Planning Commission is a staff recommendation, and you're saying that it has to be the Planning Commission?
Under the express terms of the zoning ordinance, Article 8, and I can get you the specific provision. I've got copies. I know you all have copies of the downtown code and the zoning code itself. But I've got a copy of the section that speaks to that. I'm happy to give it to you here, if the board would like it. It's section 1740, 340, limits to this board's jurisdiction. The board shall not grant variances to the following sections and tables. Section 17.37, downtown code. And then there's a footnote that gives you all the ability to grant a variance in a limited circumstance. And that footnote reads, within the downtown code district, however, variances may be granted for building height at the street and overall building height with a recommendation from the Planning Commission. And in other sections, they refer to recommendations from the Planning Commission department or the planning staff. So,
Can you speak to where the code distinguishes between Planning Department and Planning Commission?
Sure. Let me see if I can find an example.
I know that's a little tangential, but I am curious.
Okay, so here's an example of a difference. This is in the special exception, Article 7, 1740-300. Special exception uses that would otherwise require final site plan approval by the Planning Commission pursuant to Section 1740-170B may be considered and approved by the board upon consideration of a recommendation from the Planning Commission. All other special exception use applications shall be transmitted from the Board of Zoning Appeals to the Planning Department for review and a report. Upon receipt of a complete application from the board, the Planning Department shall review the application and report to the board following a 28-day review period. In its review, the Planning Department shall advise on the nature of existing and future land uses in the general vicinity of the proposed special exception use. So that's an example of a provision that at first requires something from a recommendation from the Planning Commission itself, and then in the alternative for different things, that report from the Planning Department. And my understanding, maybe I'm wrong, I'm sure the staff can correct us, but that was from the Planning Department, not that did not go before the Planning Commission. And I don't think it would have, because it was, they didn't treat it as a variance request. They treated it as a special exception instead. Does that help? Okay. All right. Thank you so much for your time.
Any further questions? Thank you for the presentation. We'll get the appellant back up here. Now you have 4 minutes and 21 seconds for rebuttal.
It won't take me 4 minutes and 21 seconds, Mr. Chairman. That seemed like longer than 10 minutes. I'm reminded of something my mentor told me a long time ago when I first started practicing law, and that is, when the law's on your side, argue the law. When the facts are on your side, argue the facts. And when neither the law or the facts are on your side, just argue. And that's what you've just heard for the last about 14 minutes. This has nothing to do with height. This has nothing to do with anything other than competition. It's not Waller Lanston's position necessarily that the special exception is the right go, at least not ours alone. It's also the position of your staff and the position of the Planning Department that this is the right way to go forward. My clients are getting ready to invest $50 million in the restoration and saving these buildings. They're not going to do it, quite frankly, unless they're reasonably comfortable, and their lawyers are reasonably comfortable, that we're on fairly sound ground legally going forward. It's unfortunate that this board, who's sort of designed to look at things having to do with design and policy, you get this legal issue thrown in front of you, and I promise you, all you've heard for the last 14 minutes is smoke and mirrors. A special exception is a perfectly appropriate way to approve what we're asking. Period. Hard stop. We've also heard for the last few minutes about mass and what's the appropriate amount of mass at this, and that somehow that our competitor down the street is a better arbiter of what the right mass is for this site than, say, the Planning Commission, who thinks this mass is appropriate for this site, the Historic Commission, who thinks this mass is appropriate for this site, the Downtown Code Design Review Committee, who thinks that this mass is appropriate for this site, the council person, who thinks that this mass is appropriate at this site, the neighbors. Even our competitor next door in the Knoll, the old Knoll, which is getting ready to be converted into a hotel, they couldn't be happier about what we're trying to do and the mass that we're putting there. The only entity in here in front of the BZA complaining about this, quote, inappropriate mass just happens to be our competitor down the street. We would ask that this board make two findings. One, that the special exception is an appropriate way for us to move forward and that our application be granted. Thank you for your time, and thank you for all that you guys do for our city and serving on this board.
So, I'm sorry, go ahead.
I was going to say, so that you understand, it did seem like longer than 10 minutes because the clock stops when the board is.
That's fine. Yes, sir.
Go ahead, David.
But what about his argument? Where is he wrong, Mr. Denton, wrong well, let's say, for instance, the difference between a recommendation from the Planning Commission versus the Planning Department, is that not? That whole
methodology, that whole procedural path is he's talking about a variance. We're not in here asking for a variance. We're in here asking for a special exception. So again, that's a little bit of smoke and mirrors. I'm not in here telling you how to change a tire on a 57 Chevy anyway, because it doesn't have anything to do with what we're in here talking about. Yes, that path, that procedural path that he spent a great deal of time explaining to you requires a Planning Commission to vote. That's a variance path. We're not on that path. We're not on that street. We're on a street that is a special exception. We've put information in front of the BZA that shows that we meet all of the criteria necessary for this board to approve an application for a special exception, and that's what we're asking for.
I appreciate that very much. And I've read your brief, which I guess will be part of the record, but can you just articulate, if you would please, how the downtown code and the zoning code interact and why you believe that both are allowed, the special exception and the variance?
Because the language in the downtown code specifically says that you can ask for this particular type of exception, if you will, via using either a special exception. It does say and. There's no question that it says and. Special exception and variance. And as somebody that works quite a bit with council as these ordinances are put together, do I wish that it said or? Of course I wish that it said or, it would be. But it doesn't say or, it says and. But when you read all of this in the context, their argument is basically a gotcha argument. They're looking at an extraordinarily narrow interpretation of what the downtown code says. What the Codes Department believes, what the Planning Department believes, what Waller Lanston believes, that you have to look at the entire downtown code and what they were trying to accomplish. And it's clear that the drafters intended for you to be able to use a special exception in those circumstances where a special exception was appropriate, or a variance. Two other things just real quickly. It's not that the variance procedure is more difficult or a higher standard, or it would require us to do something that we're not doing under the special exception. It's not that at all. It has nothing to do with it whatsoever. Variances are limited in the circumstances that you can apply for a variance. There's limitations on the particular types of particular types of circumstances that will allow you to use the variance process. In this case, it may or may not be this particular application may or may not qualify for a variance. The good thing is we don't ever have to get to that because it does apply for a special exception. It's not that we're trying to avoid the rules. It's not. I can assure you, we have been over backwards 3 times with planning, with codes, with historic, with MDHA to do every possible thing we could to make this as wonderful a project as we can. We're not trying to avoid anything. It's just in looking at the totality of the circumstances, in talking with code staff, in talking with the planning department, they said, let's use a special exception for this, and we said, let's do it.
Well, it seems like there'd also be an advantage from the planning department and the historical commission's perspective on the special exception, and the sense that a variance doesn't necessarily apply to a specific project. You could change your mind. A special exception, for the most part, is project specific with the staff's judgment of how much it deviates from the plan presented. And so if we did the special exception, it would apply to this plan as presented, which would meet the criteria that the agencies have. It seems like that would be in the best interest of those agencies to recommend this and say it is appropriate and it's the most appropriate. So I can understand why that would evolve toward that answer.
The city writ large, from the mayor's office to codes to planning to historic to MDHA, they had one goal in mind, and that is save these buildings. Make these buildings something extraordinary again, like they used to be. And so we worked on that a long time, and then when we got to a design, then we said, okay, how do we, from an administrative standpoint, from a procedural standpoint, accomplish our goal, save the buildings? And what we came up with together, working together as partners to save these buildings, was the special exception path forward, and that's why we're here today.
Great, thank you.
So I still think a crux of this argument is the and/or issue, oddly enough. And in fact, your brief, or I guess your company's brief, I don't think you said someone else wrote it, but it does say in the third paragraph, in working with the Codes Department and planning staff, we were advised that a special exception would be the appropriate vehicle, in quotes, to use for this request because the downtown code, page 14, clearly allows for an application to pursue either a special exception or a variance, and there is absolutely nothing in the zoning code that prohibits someone from applying for a special exception to allow additional height within the downtown code. So could somebody actually read that, please? Do we have a copy of that?
It's in the Waller. Is it? Are you talking about it's in their proposal, but it's not to get off D. But to me, it's under a heading called variances and special exceptions, and then it says variances and special exceptions that are not specifically, and this may be getting into discussion, but I'm just saying it's under the header of the paragraph implies one or the other.
I think we can ask the question here. You're referencing the attachment. What we're referencing is Exhibit D to your brief. And if you'll look, he's got it highlighted there. And so your brief says either a variance or a special exception. That's your interpretation of where it says variances and special exceptions.
Yes, ma'am.
Okay.
Our interpretation and code's interpretation and planning department's interpretation. And I could go through the whole list again, but I won't because they haven't turned my clock back on, but I'm boring you, I'm sure.
And because we heard it, we understand.
Any further questions? We'll close the public hearing. Thank you.
And I guess the only other thing is just for the record that the zoning administrator does believe that the special exception is the right way to go or the appropriate path, and that
I do, and here's why. Because the downtown code was written by the planning department. It's administered by the planning department and not by my department. And if the planning department They wrote the downtown code, they administer it, and if they say the special exception is the way to go, then that's what I believe.
Other comments, questions?
Well, I have a comment. I think that the applicant went through many steps and many meetings. We would have asked them to do the same thing had they come before us. I'm mindful of the opposition, which that's what lawyers do. He's pointed out an interesting argument that he may have, but I think what's before us is if the zoning administrator believes that they're here on the appropriate vehicle, and if they meet the criteria for that vehicle, which I believe they do based on the presentation, then it seems to me that we would approve the request.
Yeah, I mean, I've been on this board, I think, almost 3 years, and I've never seen a project that had this much effort, unanimity in terms of the agencies across the city and the neighborhood. So I think they've done all their homework. I think they've done it well. And the way it was brought to us, I agree. I think that there's ample evidence to support that those responsible knew the appropriate avenue, and I think that this is probably an appropriate avenue. So I would say of the finding that the special exception was the way to go, I certainly agree with that, and I certainly support the project.
David?
I'm still reviewing. I'm listening, but I'm still reading.
I mean, we looked at that, page 14, and that both sides presented and had different interpretations. The header of the paragraph says variances and special exceptions. To me, that implies one or the other. Apples and oranges, hamburgers and hot dogs. I mean, that is the title of the paragraph, and then it repeats it in the very first thing. I don't think it's written in a way, the way I read it, and other people may read it differently, but the way I read it, and I think the way codes and the planning department reads it, is that a special exception is certainly an option for this type of project, and that's how I would find. So I'm happy to make a motion that we approve this proposal because it's met all of the requirements of a special exception.
Can we add to that with the recommendations of the planning department, assuming that those recommendations?
Right, and I'll amend that a motion to say that provided that the recommendations from the planning department as written and as presented are met, and that and still under the assumption that a special exception is plan specific. So.
Christina, you came in at the right time, didn't you? Anything to add?
I'll say that I don't think the code would require them to go through both a special exception and a variance, and I think that's an important point to note.
Okay, we have a motion. Do we have a second?
May I be recognized, Mr. Chair?
Yes.
I just wanted to weigh in on that particular comment that our board member just made, and no questions have been asked, but I feel like I would be remiss if I didn't comment on some of the statutory construction arguments that have been made, and that was one of the things that I actually wrote down, was that if you are looking at statutory construction and you're looking at the and the meaning of and is or, the meaning of and is and if you are saying that in this case it only means and, then you would necessarily require that you do both, and nobody here has made that argument. And so I thought that I just needed to give you some comfort in that regard, is that is also the way I read it as it relates to that specific point. There are several points that are here, but I think the board has already heard enough, so I won't belabor the point.
Thank you.
Okay, do we have a second?
I'll second.
We have a motion and a second to approve the application. Any further discussion? All in favor of the motion say aye. Aye. Opposed?
And I'm present, not voting.
Okay, we have a vote of 4 ayes and 1 present not voting. So the motion passes.
Next case.
I must say to all of you, that was an interesting presentation on both sides.
Thank you. Well, everybody get settled. We'll move to the to the next case, which has been deferred. The Bethel Outreach Ministry has been deferred to May the 7th. The next case that we have.
Mr. Herbert, do we want to have our other members step in?
Yes, we need to do that. Thank you, Ms. Chappell.
Can we get 5-minute recess?
Let's take a 5-minute recess. Thank you. Single family for a group home, for a group daycare home for 12 children. This is referred to the board under section 1716-170D. The appellant has alleged the board would have jurisdiction under section 1740-180C. Mr. Chairman, I'll hand it over to the applicant. Ma'am, it's a case with opposition. You have 15 minutes. Okay. And then we'll have 15 minutes. You may want to reserve any part of your 15 minutes for rebuttal if you would like. At this point, we'll hand over Mr. Harrison to make the presentation.
The subject property is located on the west side of 11th Avenue North, south of Cecilia. This is an aerial view, Cecilia to the north of the property. Site plan presented to us shows the house, the fence in the rear yard. That's a picture of the house from looking at it from 11th Avenue North, looking into the house. That's the properties to the left. Properties to the right on the neighboring properties to the south there. This is a rear yard showing the fenced-in rear yard. And there's another shot of the rear yard looking straight down the driveway. And that's what we have on it.
My name is Sylvia McCarthy. I have my degree in teaching, K through 12, and I've been employed at Metro for 13 years. I decided to open a daycare in the basement of my home. So far, I have, it's an open space down there. We have laminated floors with heating below it. It has a water fountain, and it's set up just like a regular classroom. I'm seeking to target those students or families in the community where, Metro already has it where they take 4-year-olds, and they will be taking 3-year-old next year. But at times, parents cannot get to their kids by 2 o'clock when the day is over, or the school may not have after-school care. And so I will be running a educational program, and the opposition as far as the parking space. The parking space is utilized for 4 cars to pull our way up to the fences. 4 cars can be, pull in, to drop their kids off. I have informed that kids will have to be signed in. They're just not let out the car and walk into the building. They do have to walk in, the parents will have to sign. And that's about it.
So, would it be just aftercare, or would?
No, this is, it'll be open from 6 to 6.
And how many?
12.
12 total. Do you have any idea? Is that 3 in the morning and we'd have all 12 in the afternoon, or 12
okay.
most of the day? I mean, it
the
doesn't really
hours-
matter, but these questions always come up, so.
Actually, if there are 12, then the drop-off time, will probably be between the predominantly, as far as when most of them may come in, maybe between 7 and 8.
And I ask this because it does go to how many trips there are, how many times cars are there. So if you had kids there, let's say school-age kids that are there before school that would get on a school bus and then maybe come back, or and I know we're only talking about 12. I'm just, like I said, I'm trying to just get a head around.
Actually, 12 3- and 4-year-olds. That's what I'm trying to target, 3- and 4-year-olds.
And year-round?
Yes.
5 days a week?
Yes.
Thank you.
Any other questions? Okay, we'll hear from the opposition.
How's everybody doing this evening? My name is Calvin Fisher, and I'm right up the street from Ms. Carter, who just got through speaking here. The problem I have, I've been over there since '68 on the same street. And I've seen 2 major incidents. One where that particular street, first of all, is made like a roller coaster. You go down and you're up on both sides, either way. And there's been so many folks come up down that hill speeding. As you looked at the home there is no sidewalks in front of the home. It's also a very narrow street. My concern would not only be for the children that would be getting in and out of cars, because there's a church across the street. Everybody's not going to park at their parking lot. Everybody's not going to park in her yard. When you have parents, with the parents of kids the age that you were talking about, that would be a part of a daycare, a lot of them would be disrespectful, which means, and not all of them, I'm just saying some. We don't know who's who. I don't know them, just like I don't know Miss McCarthy, but she seemed like a very nice lady. But issues come about. People parking on the street, doors open or doors closed, yet there's no place to park, properly park. And then someone had to swing around, go around. Whenever you have a home on the top of a hill like that, and you're going down the hill, you can't see around you. So the school down the street, which is, down from that, is a Montessori school. Although it's facing Kellogg Street, there's the same type of issue. The issue is people parking on the street. Now, they have sidewalks down there, but because the street itself is so narrow, people have to pull around. And when you're going up that street, it's blind. You cannot see as you go up the hill to see what's over there. So you have kids coming in between cars. Now, on this end of the hill, where Miss McCarthy is talking about her daycare, it's just as dangerous. You coming off the other side, coming up that hill, or whether you're going down the hill. So we had one incident over there where there was a car that was doing around about 90 miles an hour flying away from the police. Now, I know that's a situation where someone was trying to outrun the police. They came and they went straight across Cass Street, went in airborne into the back of some homes over there. There was another incident that happened maybe around about, I would say, probably about a year ago or so, something about like maybe a little longer, where someone came over the hill. They was driving very fast, and they went airborne. They went over the hedges in the house across from me, and then they went airborne and flipped and hit a car that was parked in a man's backyard. Now, when I look at elderly people going down the street, as well as myself, having to swerve to go around, and you were talking about a street with no sidewalks and that narrow, that brings about a concern. First of all, it's not a commercial area, it is a residential area. And to me, that's very important. So what my complaint is, I just don't want to see anything happen. Things can happen anywhere, we know that. But that particular location, being on the top of that hill like that, when people use that hill as a roller coaster, that's a disaster waiting to be happen. The same thing is where the Montessori school is. Although the school itself is facing Catalog Street, but people park on 11th, the same street that I live on, the same street that Ms. McCarthy is talking about having a daycare there. So this in and of itself is a problem. And Ms. McCarthy seems like a nice lady. There's nothing wrong there. I don't know the kids who would be there, who would be the parents, but I do know we're living in a time where because so many people, especially young folks, and I'm not saying this about all of them, so many of them are disrespectful, which means if I'm going down the street, I think I own the street because that's the mentality a lot of them have. So I, as a person who lives in the neighborhood, been there since 6 to 8, will have to deal with these people, whoever they may or may not be. So my concerns is this, and even though some may be decent and very respectful, and that's the kind of people that we would like to see in the community, everybody ain't gonna be the same, and we know that also. So that's what I have to say about that. My concern is for the neighbors there as well as myself and the safety of the kids, and there is certainly no sidewalks, and it's a very narrow street, and it's a disaster waiting to happen.
Any questions?
You made reference a minute ago to elderly people living in the neighborhood around, and you said, and I'm myself included, you don't consider yourself elderly, do you?
No, sir, I'm not.
Okay.
But my mother
I was going
is.
to say, whatever you're taking, I need to get some of that.
No, sir, I'm not elderly. I've been there long enough. No, sir, not at all. Not at all. But there is some elderly people live in the neighborhood.
But you don't seem to have an objection to the daycare, except other than the safety of the children? Is that?
Well, the safety of the kids as well as myself driving up and down the street, the concern of getting around, not knowing what kind of congestion that's going to bring about. I also know that with the Montessori school on the other end, which is right over the hill, there is already a problem with that because what you have is parents who picking up their children from the school there, they are next to the curb, the sidewalk. But I find myself when I go over that hill, you have to be very careful because you can't see around that curve. And if you go too fast, even though you shouldn't, because the speed zone there is 30, you'll be up on someone and you can hit someone very easily before you recognize that you're there. Now that's on the other end, but now on the end she's up on the opposite end of that hill. And it's the same thing coming from that other direction back over on this side where she's at. So you have a blinder, and that's what I'm concerned about, is the safety of not only myself going back and forth through there and kids going in and out and not knowing what type of personalities you're going to be dealing with of kids whose parents may not be, what they should be for us respecting the neighborhood, especially since it's not a commercial area, it is a residential area.
Any other questions? Okay, thank you, sir. Thank you very much. Ma'am, would you like some rebuttal time?
Mr. Fisher said it wasn't a residential, it's a residential area, and that's why the exception or permit is for is to keep it residential. You can't put in signs out, bringing business or showing that the place is a place of business. When he says there's no sidewalks up to about where if you go across the street, there's a church. And there's no sidewalks. The sidewalks stop right at the church, which is just a couple of feet but it's across from my house. But my students are not walking. The parents have to bring them and have to sign them in, and that's what I try to explain to Mr. Fisher. When he's saying parents are being disrespectful, those are the parents that I'm trying to serve in my neighborhood. I'm trying to give their students more of, or their children, more of a one-on-one, as far, because he's basically saying that they're young parents. And, you know, you can bring something to the community. Why not serve the whole community, the parents and the child? And I explained to him that, you know, they would, you know, I'm going to show them and basically inform them how to park if it comes down to that. Because, you know, there's, you know, when you let, even when I have my grandkids and I'm pulling in, I pull in, you know, the way that you're coming up so that when they do get out, if there's cars in my parking lot, in my parking, that they get out, you know, on the side of the street. So, you know, I can bring that to their attention.
Do we have any questions for the applicant? Thank you, ma'am. If not, I'm going to move to close the public hearing, start discussion. Well, I'll start. I'm cognizant and respectful of the opposition's opinions, but we, as a board, often depend on both the Planning Commission and Public Works, and Public Works showed no problems with the potential traffic, and planning noted that daycares are often or almost always in residential areas, and that is appropriate planning, and they recommended approval. Therefore, I'm going to make a motion that all of the requirements of 17.16.170D have been met, and that we should pass the request. Is there a second?
I'll second it.
Got a motion, got a second. All in favor? Any opposed? Passes. Thank you.
Mr. Chairman, we'll proceed to case number 2015-009. I'll go ahead and call the case. Mr. Cuthbertson may have an announcement, so let me just call the case to get it before you, and then we may entertain something from Mr. Cuthbertson. This is case number 2015-009. It's Dwayne Cuthbertson, appellant, and Shelby Street Partners, GP, owner of the property located at 1002 Lawrence Avenue, requesting variances in the side street, 10th Avenue South setback, and the garage door facing the side street in the R8/UZO district to construct a second new single-family 2,400 square foot residence. Referred to the board under section 1712.030C2 and section 17.20.060D. The appellant has alleged that the board would have jurisdiction under 1740.180B. Mr. Cuthbertson.
Mr. Chairman, unfortunately, the Neighborhood Association president had to leave to get back to work, and I feel like her testimony is pretty important to this case, and so I hate asking to kick this down the road yet again, but I'd ask for a deferral for one meeting just to have her testimony here. Again, I believe it's really important.
I am fine with that motion, and I admire your patience. You have the patience of Job. But I would make a motion that we defer and on the schedule proposed by the applicant. Is there a second?
Second. Would it be helpful to you to be at the first case on the meeting?
It will.
Okay.
And written testimony, we read it and we're...
And I understand that.
We don't think of it less.
I expected she was going to be here, so she didn't.
So, did we vote on this?
So we've got a motion, got a second. All in favor?
Aye.
Any opposed? Passes.
You know the way down here now, don't you?
So, Mr. Cuthbertson, you will be first on the agenda for the next meeting, and that concludes today's Board of Zoning Appeals. Thank you.